Welcome to the EladPod. Today, instead of having a town hall, we have an in-depth look at an area of policy in Missouri. Our focus on this episode is innocence. Innocent people are not supposed to be in prison, but Missouri has fallen far short of that principle on several occasions. Just a few years ago, Missouri made national news for having horrendous laws that keep innocent people in prison. Christopher Dunn spent over 3 decades in prison for a crime he did not commit. Years before he was released, a judge looked at his case and found he should be free, but the law didn't allow it.
Judge William Hickel took 2 years to render his decision, in which he wrote, coupled with evidence in the record that petitioner had an alibi, this court does not believe that any jury would now convict Christopher Dunn under these facts. But despite that belief, Dunn cannot walk free because of a 2016 ruling in the Missouri state case Lincoln versus Cassidy, which limits releases for freestanding claims of actual innocence to capital punishment cases. And you would have been better off had you been given a death sentence than the life plus 90 years.
Ronnie Lincoln's case is holding me from being free. The judge said I was innocent. Your circuit judge in Missouri said I was innocent. Kimberly Gardner, the circuit attorney for the city of St. Louis, says that I'm innocent. Why can't you free me?
Missouri's legislature eventually passed a law to allow prosecutors to try and free innocent Missourians. These special actions take a long time to prepare and to pursue, in large part because Missouri's Attorney General uses his office to oppose innocence cases, even cases like Christopher Dunn's, where multiple courts have found him to be innocent. In fact, the Missouri Attorney General's office is still arguing at Missouri's Supreme Court that the Attorney General should be able to put Christopher Dunn back in prison for a crime he did not commit. See your tax dollars at work.
The Attorney General's office is the chief legal officer. It has the duty and obligation to represent the state's interests. We are not a part, the Attorney General's office, rather, is not a party in this case, but the attorney for a party, which is the state of Missouri.
The Attorney General's opponent in that hearing was the prosecutor for St. Louis City. So that means St. Louis City taxpayers in particular get to pay double for the Attorney General's efforts to put an innocent person back in prison. The prosecutor's office argued that the legislature did not give the Attorney General the right to appeal, and that his attempt to illegally expand his power is an abuse of office. Just listen.
The state not only has a right to incarcerate persons who are guilty, but it also has the authority and the responsibility to do justice. And so that when a person has been wrongfully convicted and wrongfully incarcerated, the state has the responsibility to make sure that person is discharged.
In Missouri, unlike in other states, people who are wrongfully convicted can't go to court and assert innocence on their own unless they are on death row. They have to hope a prosecutor takes up their case, despite prosecutors in Missouri being overloaded with criminal cases already, and despite the fact that many of those offices will struggle to match up against an attorney general who routinely uses a lot of taxpayer resources to oppose innocence cases. Republican and Democratic state representatives in Missouri are proposing to change that. Here's Republican State Representative Terry Violet from St. Charles.
I'm grateful for the opportunity to present House Bill 1075. It's a bipartisan plan alongside Representative Collins, and this is to correct injustice to those individuals wrongfully convicted of a crime they did not commit. Imagine you were charged and convicted of a crime that you didn't commit. Decades have gone by where you missed your family, friends, birthdays, births, weddings, and everything else that life has to offer. Now, decades later, you finally have evidence that can clearly prove your innocence. But because you weren't sentenced to death, Missouri courts, unlike every other court in the nation, won't hear the evidence of your innocence as a reason to get out of prison. To me, that's not right. Innocent people who have conclusive proof of their innocence shouldn't be in state prisons on taxpayer dime just because they were sentenced to life without parole and not death. It shouldn't matter what your sentence is. If you're truly innocent, you should simply not be in prison.
And here's Democratic Representative Kimberly Ann Collins from St. Louis.
House Bill 731 and 1075 changes that by allowing individuals in the custody of the Department of Correction to raise a freestanding claim of actual innocence in post-conviction proceedings, this means that someone who has already been convicted and is currently serving time can bring forward new evidence of their innocence, even if this evidence was not available at the time of the original trial or appeal. What makes this bill so important and very vital is the standard of clear and convincing evidence. If this standard is met, the court will have the authority to vacate or set aside the conviction. This ensures that our justice system can rightfully correct its mistakes and that the innocent individuals do not languish in the prison due to legal technicalities or oversight. It is an opportunity to ensure that our legal system is not only fair, but that it is just. This bill is not just about overturning convictions. It is about maintaining the legitimacy of our legal system and protecting those who are innocent.
Plenty of folks showed up to this hearing in Jefferson City, and they came out to support the bill, including Kenya Brumfield Young, who pointed out the enormous cost of wrongful convictions.
The human and financial costs of wrongful convictions are absolutely staggering. Incarcerating innocent victims for just over that 712 years that I just referred to has cost Missouri approximately $14 million in taxpayer funds. Additionally, there's an estimated $32 million that could have been earned by those who are out and able to work, according to the mean salary of those in the state of Missouri. So the total economic burden of wrongful convictions, including the DNA-based exonerations, is estimated at roughly $46.7 million.
Those millions of dollars don't even include the legal bills and compensation for those wrongfully convicted, or the cost to a corrections system tasked with housing not only guilty people, but innocent ones too, or the effect that this has on our justice system as a whole when citizens of Missouri can't trust the process will get it right. Tricia Rojo Bushnell, an attorney who has represented folks who are wrongfully convicted and who is the executive director of the Missouri Innocence Project, pointed out the absurdity of Missouri's law.
I think it's really quite shocking to most of us that if you can prove you are innocent in the state of Missouri, that is not a reason to get out of prison unless you are sentenced to death. So in the hypothetical, let's say you were convicted of a murder and sentenced to life without parole, and in the years subsequent, the victim actually shows up alive. That would not be a reason for you to be released from prison.
Joshua Keyser, who was wrongfully convicted, testified at this hearing.
This last Monday, I sat in Scott County Courthouse for the first time in almost 32 years and watched another man be processed in a hearing for the murder that I was once convicted of. That's evidence that these things can go terribly and horribly wrong.
So did Rodney Lincoln, whose sentence was commuted.
When I was arrested in 1982, my children were 16, 14, 13, and 10. When my sentence was commuted by the governor to time served, even though the governor said I was innocent, all 4 of my children were grandparents with at least 2 grandchildren.
So did Kevin Strickland, who spent over 40 years in prison for a crime he didn't commit, and whose case the Attorney General opposed and delayed.
I am lucky. That prosecutor in my county was willing to hear the evidence and had the staff and resources to view my case. But it shouldn't take such luck. Innocent people don't deserve to be in prison, regardless of the sentence. It's a sad state of affairs that I would have been better off if I had been sentenced to death, because I would have had an attorney right there, and anything I would have thrown in the court, I would have been represented right on. I urge this committee to support this legislation and give every innocent person a fair chance to gain their freedom.
Almost everyone in the room came to support these bills to allow innocent people to go free. But one familiar office provided testimony in opposition.
Now we will jump to folks in opposition to these House bills? Do we have anyone in opposition?
Good afternoon, members of the committee. My name is Jay Atkins. I am First Assistant Attorney General at the Attorney General's Office.
Good afternoon to the Missouri Attorney General's Office, too.
I think this bill undermines the rule of law and is a miscarriage of justice, and if what's worse is it's doing it on the backs of victims. There's no mention in here about victims' rights or victims' access to these processes. I would take exception with the proposition that it is a foregone conclusion that the state would have a seat at the table in this. The legislation is not drafted that way. I would remind this committee that under 547-031 that was passed 4 years ago, our office has been to the Supreme Court on that case no fewer than 7 times to make sure that the state has the proper opportunity to be heard and represent the integrity of the underlying conviction in these cases. As of now and for the foreseeable future, our office will remain strenuously opposed to what we think is a very bad bill, both on its terms and as a matter of public policy.
So I guess I have an issue with your comment that this is a miscarriage of justice. I mean, if somebody was actually innocent and it was found that they could be released, and we did it if it's done under the normal procedures and they were released, and that's appropriate, and if we add one more step in, how does that one more step all of a sudden become a miscarriage of justice?
How many steps are we going to add before we, how is adding perpetual avenues for people to make disingenuous claims of evidence, how does that not undermine our system of justice?
Maybe the fact that we have innocent people who cannot get out of prison undermines our system of justice in Missouri. Maybe that's the problem. This guy is talking about disingenuous claims while helping lead an office that has filed disingenuous responses in court to try to keep actually innocent people in prison time and time again. The man questioning the Attorney General's office is State Representative David Tyson Smith, an attorney from Columbia.
Well, so say you said you have to go through 8 steps, and say
I did not say you have to go through 8 steps. I say there are 8 different avenues that you can approve.
Well, say you go through the steps or the avenues, and you've availed yourself of the last avenue, and it doesn't work. But then the next you do one more. Does that make it disingenuous? I mean, if you have one more opportunity, all of a sudden now it's disingenuous?
So look, we can play this slippery slope game all you want. The reality is what this bill does is it gives the 40,000 people who are incarcerated and the 50,000 people who are under the supervision or on probation of the Department of Corrections, and it gives them an immediate, on August 29th, if this thing were to go into effect, it would give all 90,000 of those people the right to file a petition of actual innocence, whether frivolous or not, supported by not evidence, but rather information, which is not defined, and it gives them an avenue to file those 90,000 petitions with the court, and it compels the court to take up those claims and have a hearing, and it gives nobody the right to come to court and defend the veracity of the underlying conviction. It completely cuts the state out of the process, other than to take the judge whose job is to call balls and strikes and be an umpire and turn them into a player who is now supposed to be the sole fact finder on evidence and or information that may be up to 20, 30, or 40 years old, because there's no statute of limitations in this thing either. So if that amount of chaos does not undermine our system of justice, I'm hesitate to come up with an idea that better illustrates the problem. That undermines our system of justice.
Just a tip for the viewers out there. It helps to read the bill before coming to testify about it. And this bill is also very short. Here it is. The bill allows folks alleging that they are innocent to bring a claim of innocence under a currently existing procedure. They have to meet a very high standard to prove their innocence too, by clear and convincing evidence. The current process, as this guy well knows, allows prosecutors or, more frequently, the Attorney General to oppose the innocence claim. This was discussed right before the Attorney General's office came up to testify in this hearing.
Okay, so is the procedural posture, like I have State versus Smith, is it like that, the claim that I make there? Or is it I file a new claim, Smith versus State, a civil lawsuit separately?
So the way that this legislation is drafted, you would be allowed to bring the actual innocence claim in any proceeding you're already allowed to file. So that could be a post-conviction claim, right, which would be a 2915 where it becomes, Smith versus state. It could also be a state habeas, which is a Rule 91 claim. Those are usually called like ex-rel,
Right.
So it doesn't change the processes available, just that type of claim that can be heard.
But if you use that language, there has to be some existing mechanism for you to get in court, whether it's a habeas claim or a motion on my post-conviction criminal case, right? But
Exactly.
if I have some mechanism there's an underlying cause of action that allows me to be in court and I'm convicted, I can make a motion to say I'm innocent. I want a hearing.
Correct. And so when we file, certainly the state, whether that be the Attorney General, the prosecutor's office, will come and say, these pieces have been heard or this has been heard, and they will raise those claims. And we always have to explain what's new and different. So if the proceeding is a motion under the Rule 91 proceeding, the Attorney General is the responding party to that. In state post-conviction, it is often the county attorneys, though often they have invited the Attorney General to come in as well. So whoever it would normally handle that process.
So you think you were selecting the representative of the state by the method in which I'm adding this motion to my claim?
Yes, we don't want to change anything about processes. We just want to make this an available claim.
No, that's fantastic. Thank you.
The Attorney General can sleep well at night knowing that he will still have the ability to try to keep innocent people in prison. Goodness forbid he lose that opportunity. That's apparently a really big motivating factor for the office, considering how worked up the assistant got during this hearing.
Well, and I guess going back to your original statement about these disingenuous claims, I mean, if people are availing themselves of the process that's currently in place, I don't see how you could say it's disingenuous when you just before that said that was the appropriate remedy if they got out. So obviously, if people are filing their claims and they're getting out, and you think that's appropriate, it's not disingenuous.
Yeah, and they're doing it under the laws. They're doing it under the laws that already exist, Representative.
Right,
so
right.
you're
And so
making
you
my
add-
point.
you
You're
add-
making my point for
okay,
me.
and so we add one more step.
Yeah, how many are we going to add? When do we get finality for victims? When do we get finality for victims, Representative? When do victims get a Florida flag?
This is my inquiry, gentlemen.
Apparently, not only does this guy not read the bills he's testifying about, he also doesn't understand the justice system he's supposed to be overseeing at the Attorney General's office. It does not help victims to keep innocent people in prison. That just means the bad guy is still out there. The government screws up all the time. If you're skeptical of big government, if you believe that people make mistakes, and if you believe it is immoral to punish someone for something they didn't do, then you want to at least give folks some method to escape those unjust circumstances. That just makes sense. Sure, there will be some folks who petition the court and claim that they are innocent when in fact they're not. That happens even under the current system we have right now without any of these bills. And courts are charged with figuring out who is right and who is wrong. That's one of the reasons we have a court system in the first place. These bills won't change that. All they do is they give someone like Christopher Dunn or Kevin Strickland or the many other folks like them a way to get out of prison when they are not supposed to be there. But Missouri has an attorney general who unfortunately couldn't care less about those who are wrongfully convicted and is willing to spend a lot of our money keeping them in prison.
I guess what concerns me, gentlemen, is it concerns me of your tone. I mean, you represent the Attorney General, and you're talking about people who could potentially be innocent, and you're coming in here in almost a hostile manner, talking about miscarriage of justice. Frankly, I find that's disgusting, especially if there's people that are actually innocent. And I would think there'd be a little more give and play. You might be down the middle on the issue and be more open-minded. But to come in here with a hostile attitude and call it a miscarriage of justice, I think is frankly gross.
Yeah, it is. So what can you do about it? Well, you can contact your state representative and state senator and ask them to support House Bills 731 and 1075. I would tell you to contact your attorney general too, but that would actually be disingenuous.